Good afternoon. Today we are having a conversation that makes many uncomfortable. Not because it's untrue, but because it exposes truth that the deep state has carefully buried for 75 years. We're not here to whisper, we're here to state facts. And the central fact is this: the majority community in India, despite being in their own civilizational homeland, are treated as second-class citizens, not. And let me be unequivocally clear about something at the outset. We're not discussing political appeasement today. Every party appeases. That's the nature of electoral democracy.
What we're discussing is far more sinister. We're discussing state-sponsored, state-sanctioned, constitutional apartheid. The issue is not that some communities receive preferential treatment. The issue is that one specific community faces active discrimination embedded in our legal framework.
Here's what people don't understand. Appeasement is political theater. Discrimination is structural violence. When a political party announces a scheme for one community to win votes, that's appeasement. We can see it, call it out, vote against it. But when your constitution itself contains provisions that treat you as a lesser citizen, when laws are framed specifically to target your places of worship, when judiciary itself refuses to hear your grievances, that's not appeasement. That's apartheid.
We will present specific, documented instances of this apartheid, not opinions, not allegations, facts, legal provisions, Supreme Court judgments, government data.
I want to borrow a phrase from the Indian jurisprudence, stare decisis. It means to stand by things decided. The deep state has stood by decisions made during colonial rule, decisions made during partition's trauma, decisions made to fracture the majority. Today, we ask, how long will you stand by this injustice?
Let's begin with what we call the largest financial scam in independent India. Not coal scam, not 2G, not even Commonwealth Games. We're talking about the systematic loot of places of worship belonging to the majority community. And here's the beautiful irony. This loot is legal.
And the numbers are staggering. 10 states control over 1,100,000 places of Hindu worship belonging to the majority. Tamil Nadu alone controls 44,000 temples and 40 religious institutions. Karnataka controls 34,563. Kerala, a state run by communists who call religion the opium of the masses, controls 1,200 temples through 5 boards.
Let's understand the constitutional perversity here. The state claims we are a secular nation. Secular, by definition, means total separation of religion and state. Total. But is it? Only one community's place of worship are under state control. Can you imagine the state appointing priests at Jama Masjid? Can you imagine government officials deciding how many times namaz should be offered? Can you imagine bureaucrats controlling church property?
But this is exactly what happens with Hindu temples. The state decides everything. Who will be the priest? How many times puja will be performed? What will be the size of the prasadam? And how much money can be spent on rituals? Down to even the weight of the prasadam, the laddu. Here's the kicker. The state levies an administrative charge of 15 to 25% on temple income. So essentially, a Hindu donates to his temple and the state takes a cut for administration.
Let's talk about the financial hemorrhaging. Tamil Nadu temples own approximately 10 lakh acres of land, prime land. If properly managed, this should generate a minimum of 6,000 crores annually. How much does it actually generate? 150 crore. That's 1%. Where did the 5,850 crores go? Into the deep state's coffers? Into corruption? Into deliberate mismanagement?
The Kapileshwara temple in Chennai owns over 700 acres of prime property. State records show 500 plus defaulters. The land is encroached, the revenue is lost, and this is just one temple. Multiply this across 100,000 temples. The loss runs into lakhs of crores over decades. Meanwhile, this temple ecosystem, which for millennia funded education, built schools, established gurukuls, ran hospitals, maintained orphanages, all of that has been systematically dismantled.
Here's a specific example that should enrage every citizen. The Ardhanarishwara temple in Tiruchengode generates over 1 crore rupees annually. How much is allocated for daily worship? 7 lakh rupees. That's less than 10%. Where does the rest go? And in Tamil Nadu, 46,000 temples, 46,000 don't have enough money to perform even a single daily puja. These temples generate crores in income, but they can't afford basic worship. How?
The Tirupati temple, one of the richest religious institutions in the world, between April and September 2020 alone, the hundi collection was 530 crores. The government valuation of its properties, 86,600 crores. And all of this is controlled by the Andhra Pradesh state government through specific legislation. The deep state even had a provision, since struck down by courts, that temples earning 5 lakhs or more must pay 6.5% of income to the endowments department as tax on donations made to God.
Now let's talk about the legal framework of this apartheid. It begins in 1817. The British passed the Madras Regulation Act. Then came the Religious Endowments Act of 1863, then 1951, then 1959. And here's where it gets interesting. When the 1951 Act was challenged and the Supreme Court struck down its draconian provisions, what did the Congress government do? In 1959, it passed an even more draconian legislation, essentially giving the middle finger to the Supreme Court.
An act stands to this day. In 2004, 2 religious leaders filed a petition in the Supreme Court to free temples from state control. That petition has been pending for 19 years. But the same Supreme Court can conduct midnight hearings to grant mercy to terrorists. This is what their priorities are.
Here's what makes this constitutional apartheid. Not a single place of worship of any other community is under state control. Not one mosque, not one church, not one gurudwara, only Hindu temples. And the state appoints non-Hindus, Muslims, Christians to boards that control Hindu temples and Hindu money. Imagine the reverse. Imagine a Hindu priest controlling Jama Masjid. The country would burn.
The legal architecture here reveals the state's intent. When you control religious institutions, you control the community's social capital. You control their education ecosystem. You control their financial independence. For thousands of years, temples were centers of not just worship, but learning, trade, economy, even statecraft. Every invader knew to dismantle this civilization, first dismantle the temple ecosystem. The British understood this, and the state has continued their project.
So here's my question to the government, to any government. If a Congress government could pass legislation in 1959 to control Hindu temples, legislation that still stands, why can't the current dispensation pass legislation to free them? Why build a 339 crore corridor when you could free temples to build hundreds of such corridors with their own money? Why this tokenism?
Now, let's move to what I call deliberate amnesia. For 33 years, 7 lakh people, 700,000 Kashmiri Pandits have been refugees in their own land, Kashmir, and the nation has simply moved on. Business as usual, cricket matches, elections, festivals, as if these people never existed.
Let me paint you a picture. January 19th, 1990. Mosques across the valley blare slogans, not calls to prayer, slogans, Raliv, Saliv, Galiv. Convert, run, or die. Death to Kafirs. Leave your women behind. We want Pakistan. And what was this?
The word genocide can be used loosely nowadays. Let us give you a precise legal definition as per the UN Convention. Genocide is acts committed with the intent to destroy in whole or in part a national, ethnic, racial, or religious group. What happened in Kashmir meets every single criterion: targeted killings, mass exodus, systematic erasure, and yet today the deep state refuses to call it what it is.
Let's talk about specific cases because when you speak in numbers, 7 lakh people, it becomes abstract. Let's make it real. Girija Tikku, a woman who was gang raped by terrorists, and then, while she was still alive, they cleaved her into two with a mechanical saw. A mechanical saw. Do you understand what that means? The deliberate, slow torture while she screamed for mercy.
BK Ganju. He hid inside a rice barrel when jihadists came looking for him. His Muslim neighbor informed on him. They found him. They shot him dead inside the barrel. And then they took that rice soaked with his blood, and forced his wife to cook it and eat it. This is what happened, not in medieval times, in 1990.
The Nadimarg Massacre, March 23, 2003. A terrorist named Zia Mustafa lined up 24 people, men, women, and children, and shot them point blank, one by one. And as he was leaving, he heard a baby cry. His accomplice said, "Ye karna wa chupe," finish this too. And that baby became the 24th victim. These are documented facts. Where is the justice?
Now, a recent film attempted to tell this story, and what happened? Prominent voices, politicians, intellectuals, activists called for it to be banned. Banned. Why? Because they said it was one-sided. I want someone to explain this to me. What is the other side of genocide? What is the other side of rape and murder? Was the rice soaked in Ganju's blood not red enough? Was Girija Tikku's torture not balanced enough?
And here's the legal horror. 5 years ago, the Supreme Court of India rejected petitions to reopen cases of criminal atrocities against victims. The reason? Too much time had elapsed. Read that again. Justice is now time-bound. If you survive long enough, your oppressor goes free. And in December of 2022, the Supreme Court reiterated this position. No reopening of cases. The message is clear. Run out the clock and you can get away with genocide.
Meanwhile, the state has rehabilitated, even honored these people responsible. Sayyid Ali Shah Gilani, a man who has openly called for jihad, who said Kashmir must become an Islamic state, who invited Afghan mujahideen to liberate Kashmir from India. This man was feted by journalists, politicians, and even judges. And when he died, politicians mourned him, mourned a man who orchestrated ethnic cleansing.
Let me read you Gilani's own words from his book. Quote, India is a bigger enemy of Islam than even Israel, unquote. Quote, Muslims are a separate nation on the basis of their religion. Their unity cannot be based on homeland or race. The basis of their unity is Islam and Islam alone. Kashmir must become an Islamic state. Our struggle is for the sake of Islam, unquote. These are his words, and yet the state broke bread with him for decades.
And here's what's happening right now. Tourism in Kashmir is at an all-time high. 1.88 million tourists this year. Hotels are full, houseboats are booked, business is booming. But here's the catch. They want the majority community to come as tourists, not as residents. They want them to fill coffers, but not reclaim their land. And the state facilitates this. It settled 5,700 Rohingya Muslims in Jammu and Kashmir. But it can't settle 7 lakh people who were born there, who lived there for millennia.
Let's talk about the government's rehabilitation efforts. In 6 years, only 17% of promised houses have been completed. Through the Prime Minister's job scheme, only 5,900 people have been employed. Meanwhile, in the Vesu transit camp in Anantnag, people are locked in. They can't even step out to buy milk or medicine. Is this freedom promised to the original inhabitants?
Here's a personal story that encapsulates this tragedy. A man named Uttar Kaur. Every year on January 19, he brings out from under his mattress a crumpled piece of paper, a bus ticket, dated January 19, 1990, the day he fled. His son, Aditya, now a journalist, was 1 month old. He was smuggled out in the jute bag. For 33 years, that father has kept that bus ticket under his mattress. Why? To remind himself that he will return, to remind his son where they came from, to ensure future generations never forget.
This is what annihilation looks like. Not just physical displacement, temporal displacement. These people have been in exile longer than Israel was scattered. But Israel returned. Israel rebuilt. What about India?
Post-2019, after constitutional changes, terror attacks are down 70%. Law and order incidents have reduced dramatically. But here's the reality. Only 5,000 people have been brought home. And of those, over 40 have been killed in targeted attacks. So the state solution is what? Bring them back one by one so they can be picked off? Is that the rehabilitation plan?
Now, let's discuss what might be the most brazen example of institutionalized discrimination. A parallel legal system, an entity that has powers exceeding those of civil courts, an entity that claims 940,000 acres of land, an entity whose motto is once ours, always ours. I'm talking about the Waqf.
Let me state a fact that will shock you. The Waqf is the 3rd largest landowner in India, larger than any private entity, 3rd only to defense and railways. It owns 30,000 estates, 400,000 properties comprising nearly 1 million acres. And here's the beautiful part. 77% of Delhi sits on Waqf land. The Delhi High Court, Waqf land. Central Vista, Waqf land. CGO complex, Waqf land.
Mukesh Ambani's house, the most expensive private residence in India, Waqf land. How is this possible? How did one entity accumulate so much property in secular democracy? I'll tell you how. Colonial appeasement. Much of this land dates back to the 1810s when the British were cutting deals to pacify one community. And post-independence, rather than audit this, rather than reclaim it, the state expanded it.
In 2014, March 3rd to be precise, the outgoing UPA government made one of its last decisions. It gifted 123 prime central Delhi properties to Waqf, properties that had been under government control since independence. For 67 years, these were government properties, and overnight, they became Waqf. This is not conspiracy theory. This is documented fact.
But here's where the legal architecture becomes truly Orwellian. let me walk you through the Waqf Act, 1995, Section 4. The Waqf Survey Commissioner has powers equivalent to a civil court. The entire cost of surveying paid by the state. So if Waqf decides your property is theirs, they will survey it, and you, the taxpayer, will fund that survey. That's Section 4.
Section 40. This is where it gets dystopian. The Waqf board can decide if any property is Waqf property. And here's the beautiful part. The burden of proof is on you. You have to prove that the land is not Waqf land. Until you prove otherwise, it is Waqf land. And the board's decision is final unless overturned by a tribunal. A tribunal that, by the way, is constituted by the Waqf itself.
Section 54. Removal of encroachment. If Waqf claims your property and you are living on it, they can declare you are an encroacher. Not through civil court, not through due process. The chief executive officer of Waqf can simply serve you a notice and you must vacate. This is constitutional. This is democracy.
Section 85. No suit or other legal proceeding shall lie in any civil court in respect of any dispute relating to Waqf. Read that again. Civil courts have no jurisdiction. The only recourse is the Waqf tribunal. So Waqf investigates, Waqf decides, Waqf adjudicates, legislature, executive, judiciary. All three powers in one entity.
And Section 107, the coup de grace. Nothing contained in the Limitation Act 1963 shall apply to the suit for possession of immovable property compromised in any Waqf. In plain English, there is no time limit. Waqf can claim your property today, even if your family has lived on it for 500 years, because the Limitation Act does not apply.
So where does this principle come from? From a 1976 Supreme Court judgment and the memorable phrase used by the Honorable Justice Dr. Anand, quote, once Waqf, always Waqf, unquote. That's now the motto of the Waqf management system of India's official website. Once Waqf, always Waqf. Property belongs to Allah in perpetuity, cannot be gifted, cannot be inherited, cannot be sold.
Let me give you real examples of this system in action. A 1500-year-old temple, the Chandrakeshwar temple, claimed as Waqf land. How? By what logic? By what evidence? Doesn't matter. The Waqf board decided that Gyanvapi Mosque, built on the ruins of a demolished temple, claimed as Waqf. No discussion about what was there before. No discussion about how it came to be. Just, it's Waqf. Discussion closed.
Now let me ask you something. The Waqf board, who heads it? Who are the members? Exclusively from one community. Can a Hindu be a part of the Waqf board? No. Can a Christian? No. So we have an entity funded by taxpayers whose properties are surveyed at state expense, whose tribunals supersede civil courts, whose members are exclusively from one community. And we call this secularism.
The Uttar Pradesh data is revealing 13,000 Sunni Waqf properties and 2,300 Shia Waqf properties. Separate boards for subsects of one religion. Meanwhile, 100 Hindu temples are controlled by governments that appoint non-Hindus to their boards. The contrasts couldn't be starker.
What we have here is a parallel government. The Waqf has its own legislature, the board that makes decisions, its own executive, surveyors and officers who implement its own judiciary, the tribunal that adjudicates. It supersedes civil courts. It overrides the Limitation Act. It is accountable to no one. And the deep state not only permits this, but funds it with taxpayer money.
This violates Article 14, 15, and 25 of the Constitution. First, Article 14, equality before law. How is it equal when one community has a separate legal system? Article 15, no discrimination on grounds of religion. How is this not discrimination? Article 25, freedom of religion. When Hindu temples are under state control and Waqf properties are autonomous, where is the equality?
And yet, when you raise these questions, you're called communal. When you point out these facts, you're called divisive. When you ask for constitutional equality, you are called a supremacist. This is the state's greatest achievement, to make the majority apologize for asking for equal rights in their own land.
Now, let's talk about how the state uses education as a tool of demographic engineering. The Right to Education Act 2009 sounds progressive, doesn't it? Right to education. Who could oppose that? But here's what they don't tell you.
Section 12 of the RET Acts mandates that all schools must reserve 25% of seats for economically weaker sections. Sounds fair, right? But here's the catch. It applies only to non-minority schools. Minority institutions are exempted under Article 30 of the Constitution, so Hindu-run schools must comply. Christian and Muslim schools are exempt.
Let's understand the financial burden. The schools must admit these students and wait for government reimbursement. A 2017 CAG report documented that reimbursements are delayed by over 200 days on average. The schools must bear the cost meanwhile. Many schools can't. The result? Over 10,000 schools run by the majority community have shut down. In Maharashtra alone, 7,000 schools received closure notices.
But wait, there's more. Hindu-run schools must follow government-mandated teacher selection procedures. They must meet specific infrastructure requirements. They face regular inspections. Minority schools? Exempt. They can hire whom they want, build what they want, teach what they want, all protected under Article 30.
Meanwhile, the state funds minority institutions. The University Grants Commission provides grants to minority institutions that keep 50% seats reserved for their own community. So taxpayer money, including Hindu taxpayers, funds institutions that practice exclusionary admission policies.
Let's talk about Aligarh Muslim University. How diverse is it? Dalit students, 0.2%. Dalit teachers, 0.15%. In a country where Dalits comprise nearly 20% of the population. But this institution receives crores in government funding. Audited? Questioned? No, because Article 30 protects it.
Here's the game. Burden Hindu institutions with compliance costs, delay their reimbursements, impose quotas, force closures. Meanwhile, fund minority institutions that practice discriminatory admission policies. Over time, Hindu educational infrastructure collapses. Minority infrastructure flourishes, and this is done legally, constitutionally.
The National Commission for Minority Educational Institution grants minority status. Who are the members of this commission? Can a Hindu be a member? No. So people from one community decide which institutions get exemptions from the RTE Act. And Hindu-run institutions, even those serving underprivileged Hindu children, get no such exemption.
This is engineered collapse. For thousands of years, temples ran pathshalas, gurukuls, educational institutions. The British dismantled that by taking control of temple wealth. The deep state continued that project. The result? Hindus, despite being the majority, have no autonomous educational ecosystem. Meanwhile, minority communities built universities, schools, madrasas, all protected, all funded.
Now let's discuss laws that explicitly discriminate based on religion, not implied discrimination, explicit discrimination written into legal code.
Bigamy. For Hindus, it's legal under Section 494 of the IPC. 7 years in jail is their penalty for doing such a crime. For Muslims, Section 2 of the Muslim Personal Law, the Shariat Law Application Act in 1937 explicitly permits it. Same country, same law, two standards.
Child marriage. The Prohibition of Child Marriage Act applies to all citizens, but courts routinely permit Muslim girls to marry upon reaching puberty, even if they are below 18. Why? Because Muslim personal law permits it. So the act applies in name, but not in practice.
The Hindu Code Bill extensively codified and reformed Hindu personal law. Hindu Marriage Act, Hindu Succession Act, Hindu Adoption and Maintenance Act. Every aspect of Hindu life is regulated, modernized, reformed. Has there been similar codification of Muslim personal law? No.
In 2011, the state attempted something truly Orwellian, the Prevention of Communal and Targeted Violence Bill. The language was careful, but the intent was clear. It de facto defined perpetrators as the majority and victims as the minorities, or CS/CST. In other words, guilt was presumed based on religious identity.
The state codifies, reforms, regulates, and controls Hindu practices through legislation while leaving other communities alone. To presume Hindu guilt and minority victimhood in law itself, to create a legal framework where being a Hindu is a disadvantage by default. This is leading towards a future where being Hindu is criminal by default. It already is in many countries.
The judiciary is supposed to be the protector of constitutional rights. But when it comes to religious matters, the judiciary has become a tool of selective reform. It intervenes aggressively in practices of one community while maintaining studied silence on others.
2018, Sabarimala case. The Supreme Court strikes down the tradition of a celibate deity, centuries-old tradition, millions of devotees. The court decides it's discriminatory. Justice Indu Malhotra, the lone dissenter, writes something profound. Notions of rationality cannot be invoked in matters of religion. She was overruled. The court decided it knew better than the devotees and the deity himself.
The Amarnath pilgrimage to 2017. The National Green Tribunal banned bells and shlokas. Yes, you heard it right. Devotees couldn't ring bells or chant shlokas because of noise pollution. But the azan on loudspeakers 5 times a day? No court dares to touch that.
Jallikattu, banned by the Supreme Court. Dahi Handi, the Krishna Janmashtami tradition of human pyramids, restricted to 20 feet in height. The court mockingly asked if Krishna indulged in acrobatics. This is how traditions are ridiculed. In Tamil Nadu, the Patina Pravesham, a temple entry ritual, was temporarily banned. The courts have no hesitation in dictating how Hindus should worship.
July 1st, 2022, Nupur Sharma case. She quoted from Islamic texts. For this, multiple FRIs were filed against her across the country. She approached the Supreme Court to club the FIRs. The court refused. But worse, the court orally blamed her for igniting the whole country. A sitting Supreme Court judge connected her statements to the beheading of Kanhaiya Lal in Udaipur. This is institutional vilification.
Let's contrast that with what the courts couldn't touch. Halal slaughter, Muharram self-flagellation with blades and chains, azan on loudspeakers at 5 a.m., burial practices that violate environmental norms, madrasas where modern education is absent, dietary restrictions that segregate children. The courts are silent. Why? Because intervening there would be communal.
Here's the principle. Reform Sanatana Hindu Dharma, modernize it, rationalize it, question every practice, every tradition, every belief, but leave other religions untouched and give privileges in the name of appeasement, because questioning them would violate secularism. This is the state's judicial doctrine: aggressive intervention for one, protective abstentionism for the other.
So Hindus can't perform Jallikattu, but halal, slowly bleeding the animal through the throat, is fine. Hindus can't even perform processions with music, but azan on loudspeakers is fine. If Hindus can't determine who enters the temple, but others can define their religious spaces, this isn't equality. This is targeting.
Now we come to perhaps the most disturbing aspect of this apartheid: the state's celebration of those who committed genocide against Hindus. Not just tolerance, celebration.
Let me ask you a question. Is there a Hitler Road in Tel Aviv? Is there a Gobis Avenue in Berlin? Is there Pol Pot Street in Phnom Penh, Vietnam? No. Because those nations understand that you don't honor those who killed your people. But in India, we have Aurangzeb Road in the national capital. Until recently, we had it.
Aurangzeb, who beheaded Guru Teng Bahadur at Chandni Chowk, who had Sambhaji Maharaj, Shivaji's son, tortured and decapitated, who demolished the Kashi Vishwanath temple in 1669, a man estimated to have killed 4.6 million, and the state named roads, cities, and localities after him.
Bakhtiar Khilji destroyed Nalanda University, one of the world's oldest centers of learning, burned countless of Hindu manuscripts. What did independent India do? Named a railway station, Bakhtiarpur, 40 miles from Patna, named a city after him. This is how we honor scholarship, by celebrating those who burned libraries.
Babur, the first Mughal emperor who called himself Ghazi, slayer of infidels. In his own memoirs, the Baburnama, he writes, "For the sake of Islam, I became a wanderer. I battled infidels and the Hindus. I became Ghazi." End quote. And we have Babur Road in central Delhi. The man boasted about killing, and we honored him with a road.
Saint Francis Xavier, chief proponent of the Goa Inquisition, in his letter he wrote, "Hindu gods and idols are as dirty as they are ugly and horrible to look at. Witnessing the destruction of temple idols gives me so much joy." This man is venerated. Millions visit his tomb every year.
Tipu Sultan, portrayed as a freedom fighter, the reality, he destroyed between 800 to 8,000 temples. Historians disagree on the exact number, but all agree it was massive. He butchered the Mandyam Iyengars on Diwali, massacres in Coorg, massacres in Calicut, but we build statues, named universities, and celebrate his birthday.
Meanwhile, the Places of Worship Act 1991 ensures that structures built on demolished temples can never be reclaimed. The Gyanvapi Mosque, built after demolishing Kashi Vishwanath Temple in 1669, documented in Masir-e-Alamgir, a contemporary Mughal chronicle, Mathura Idgah, built in 1670 after demolishing the Krishna temple. The idols were brought to Agra and scattered under a mosque's steps to be trodden on.
The 1991 Act freezes the religious character of all places of worship as they existed on August 15, 1947. So if a temple was demolished in 1669 and a mosque built on it, that mosque's status is frozen. No legal recourse, no historical rectification. The 2019 Ayodhya judgment ratified this act. The Supreme Court called it preservation of secular values. Which secular value celebrates destruction?
We've documented several areas of state-sanctioned apartheid, but here's another dimension to this persecution that reveals the true hypocrisy of those who claim to protect Hindu interests. What happens when someone actually tries to revive the Hindu civilization, what happens when a spiritual leader revived the first and only sovereign Hindu state, the answer is chilling.
Let me introduce you to a case that exposes the deep state's ultimate game. The Supreme Pontiff of Hinduism, Bhagavan Sri Nityananda Paramashivam, the ecclesiastical head of 2 billion Hindus, who has revived KAILASA, the united ancient enlightened Sanatana Hindu civilizational nations. And for this, he has faced nearly 15 years of systematic persecution, false accusations, assassination attempts, and media vilification.
Here's what makes this constitutionally significant. The Supreme Pontiff of Hinduism hails from the Aboriginal indigenous agriculture tribe of Tamil Nadu, an ethnic and religious minority. When the Supreme Pontiff of Hinduism revived KAILASA as a sovereign entity for Hindus, similar to what the Vatican, who is reviving Sanatana Hindu Dharma to its glory.
Here's the pattern. When someone uses Hindu identity for political benefit, votes, power, rhetoric, they are celebrated. But when someone actually works to revive the Hindu civilization, establish Hindu institutions, celebrate Hindu sovereignty, they are destroyed.
Those who give speeches about Hindu pride persecute those who actually build Hindu institutions. Those who promise protection deliver destruction. Why? Because empowered Hindus don't need political saviors. Sovereign Hindu institutions threaten vote bank politics.
What the Supreme Pontiff of Hinduism represents is dangerous to the deep state, because the Supreme Pontiff of Hinduism is a threat to their monopoly on Hindu identity. This terrifies those whose power depends on continuing Hindu victimhood and dependence.
So where does this leave us? We've now documented various distinct areas of state-sanctioned apartheid, temple control, Kashmiri Hindu genocide, Waqf supremacy, educational discrimination, selective legislation, judicial bias, celebration of genocide, the Places of Worship Act, and now the persecution of those who actually tried to revive the Hindu civilization.
The case of the Supreme Pontiff of Hinduism and KAILASA reveals the deep state's true face. It's not about protecting Hindus, it's about controlling them. It's about ensuring that Hindu identity remains a political tool, not a civilizational force. It's about making sure that Hindus remain dependent on political protectors, rather than building their own institutions.
But justice requires honesty, and we lack it. We lack the honesty to call ethnic cleansing what it is. We lack the honesty to call constitutional discrimination what it is. We lack the honesty to call persecution what it is when it happens to someone reviving the Hindu civilization.
Remember, those who use Sanatan Hindu Dharma for political benefit will always attack its true guardians, because guardians threaten their monopoly. The Supreme Pontiff of Hinduism, Bhagavan Nityananda Paramashivam, didn't just talk about Hindu Rashtra, he rebuilt one. And for that unforgivable act of actualizing what others merely sloganeered, he has paid with 15 years of persecution.
And this is what is going on, continuing until today. Continuous attacks against Hindus, against Hindu leaders who are standing for Hinduism, against the Supreme Pontiff of Hinduism himself, the only voice for Hindus. It's time that we as Hindus stand up and speak out. I urge each of you to visit kailasa.org, scan the QR code on the screen, learn more about how you can voice out against this ongoing persecution against Hindus, how you can become a part of the solution, how you can use your voice to stop this persecution.
The most uncomfortable truth is often the most necessary one. And this conversation is centuries overdue. So become a part of it now.
And with this, we conclude this program. And we invite each of you to continue to stay tuned to this channel and learn more about Hindu persecution and how you can become a voice for Hindus. Thank you and good evening.